So, hi everyone. I am here today because I want to dispel a myth that anyone who's ever been to the Ontario Court of Justice will be very, very, very familiar with. And I'm going to start with a screen share before I get into the meat and potatoes of this. Now, I didn't take this picture. This picture was sent to me. But if you take a look, what you see here is a sign posted on the North Bay Courthouse. And the sign says prohibition against photography, video recording, and audio recording, etc. Please note section 136, subsection, so this is what they say, section 136. Section 136, subsection 1, subsection A of the Courts of Justice Act prohibits the attempting to take or actual taking of photographs, motion pictures, recordings, audio recordings, or other such recordings unless done with the authorization of the judge at court hearings of any person entering, leaving a courtroom, of any person in the courtroom where there is reasonable ground of believing that the person is there for the purpose of entering or leaving a hearing. Also, it is prohibited to publish, broadcast, reproduce, or otherwise disseminate a photograph, motion picture, audio recording, or record taken in contravention of Clause A. Every person who contravenes this section is guilty of an offense. Oh my God, we're guilty, guys. Guilty of an offense of a conviction on a conviction and liable to a fine of not more than $25,000 or to imprisonment for a term not more than 6 months or to both. So they're intimidating you. They're telling you that if you walk into the courtroom and you make an audio recording of your hearing, you will be liable up to a fine of not more than $25,000 or imprisonment. But folks, you need to look at that. That is not what the rule actually, it's not how the rule's written. They've changed some of it. And I'll show you the actual rule in just a second. They've changed the wording of Rule 136, but they've also indicated that in Rule 136, you cannot do these recordings unless done with the authorization of a judge. Now, let me switch my screens here because I want you to take a look. The actual, here we go. There's the actual Courts of Justice Act, Rule 136, subsection 1. And it says prohibition against photography at a court hearing. Now, I'm just going to quickly. So if you remember, so this is the section I'm looking at. This is the actual subtitle. This is what the subject, so the rule relates to this subject, the one that I've just got highlighted. Let's go back to the other screen for a second. And I want you to see the difference here. They've expanded on it. Okay. It says prohibition against photography, video recording, audio recording, etc. So they've changed the subtitle. That by changing the subtitle, they're now misrepresenting what the rule to follow is. Let's look again at the actual rule, guys. Okay. So the rule actually says, Rule 136, subsection 1, subject to subsections 2 and 3. So 2 is relevant to Rule 1, subsection 1, and 3 is relevant to subsection 1. We'll come back to those in a minute. No person, so subject to subsections 2 and 3, no person shall take or attempt to take a photograph, motion picture, audio recording, Jiminy Cricket, this is me trying to work on a keypad or just a scroll pad, or other record capable of producing a visual or oral representation by electronic means or otherwise. And then it goes on to say that you cannot take I'm just going to focus on one of it because that's a lot of information. Let's just focus on one thing. You can't attempt to take an audio recording, okay, at a court hearing of what? Now, before we go on to that, I want you guys to pay attention. At the end of subsection I, at a court hearing, there's a comma. The comma means that you have to attach one of the next two lines. You know it's one of the next two lines because on the second line, there's an or. So when you see a comma, it's an incomplete sentence, which means something has to follow. So you cannot attempt, so no person, let's look at this, no person shall take or attempt to take an audio recording by electronic means or otherwise at a court hearing And now you have to attach something because that's a comma. Those are commas. So you have to keep attaching. So what do you have to attach? Well, of either a person entering or leaving a room in which the court hearing is to be or has been convened, or of a person in the building which the court hearing is to be or has been convened, where it is reasonable grounds for believing that the person is there for the purpose of attending or leaving the hearing. So now let's go back. You cannot, no person shall take or attempt to take a photograph by electronic means or otherwise at a court hearing. Let's stop. Let's go back to that other one that I was showing you a second ago, the one that's on the North Bay. And it says, it's completely rewritten. Okay, no. Please note, section 138, courts of justice prohibits the attempt. It prohibits, absolutely prohibits, they say. Let's go back. Okay, I'm going to do this. I really want to hit this home, folks. Does it say prohibit there? Does it say prohibit? It doesn't say prohibit, yet they're using the word prohibit. That's a really significant word in law. They're using it on their sign, but it doesn't say prohibit there. It just says you can't attempt to take it at a court hearing, and you can't take it of a person coming or going either from the room or the courthouse. That's what it says. You can't take it. You can't take a picture or a motion picture or an audio recording of someone coming or going from the courtroom or someone coming and going from the courthouse if you believe they're part of the hearing. Let's go back. Let's go back. So but they're implying, no, that they're not even implying, they're lying. They're actually saying it's prohibited. Didn't say it was prohibited. Far from that. But here they say it's prohibited. And then they say at court hearings, plural. It just means lump sum, everyone's court hearing. It's prohibited to do any of this at anyone's court hearing. Let's go back. What does it say? What does it actually say? No, it says at a court hearing. At a court hearing, not at court hearings blanket, every court hearing is attached. It's a court hearing. So and if you're caught doing it, they're going to charge you. Ooh, they're going to give you a $25,000 fine. Ooh, they might throw you in prison for a year. But what the law says, okay, and what this says do not mean the same thing. And what's on that window at North Bay's courthouse is a lie. It's a lie, North Bay. Take it down. Take it down now, because you are misrepresenting the law and you're deceiving people into believing that they're not allowed to record their own hearings. So take it down. And any other Ontario Court of Justice in Ontario, you better take it down, because you are all committing fraud by deceiving people into making them believe that they are not allowed to record their own hearings. Now, let me go back to the law for a second, folks. Let's go back to the law. We now know one of the many ways that our courts are committing fraud against us. So section 136, it then goes on that you can't publish or broadcast or reproduce any of these electronic communications that you may record with respect to taking it of somebody else coming or going from the courtroom, somebody else coming or going from the courthouse. But here's the thing. Here's what they don't have in that sign. Let's go back, because I'm having fun with this. Man, I'm having fun with this week, because I've been feeling really cheeky this week. They only talk about Rule 136. Now, where does it say subject to subsection 2 and subsection 3? Oh, that's right, people. Of course, they're lying to you. They're lying to you with the intent to deceive you into believing that you're not allowed to record your own hearing. So they have completely and totally forgot to mention subsection 2 and subsection 3 of Rule 136. Going back, because I'm on a roll here, going back. All right. Remember, Rule 136 subsection 1 is subject to subsections 2 and 3. Let's take a look at subsection 2. Nothing in subsection 1. Nothing in subsection 1 prohibits a person. Nothing prohibits a person. What does it not prohibit a person? Okay, nothing prohibits a person from unobtrusively making, but I'm going to go down a little. Let's go to B because that's the one that applies. Nothing in subsection 1 prohibits a party acting in person from unobtrusively making an audio recording at a court hearing in a manner that has been approved by the judge for the sole purpose of supplementing or replacing handwritten notes. Imagine that, guys. Rule 136.1 says it's subject to Rule 136 subsection 2, and Rule 136 subsection 2 says nothing in subsection 1 will prohibit a party from unobtrusively making an audio recording at a court hearing in the manner that has been approved by the judge. People, law in Ontario, law in Canada, common law is positive. So for the court to have the authority to do something, it has to be written first in law. The law, the statutes, the acts of legislation that we work with, they are the rule books. Okay, when you see the Courts of Justice Act, the Courts of Justice Act is a piece of legislation that sets out the rules for court in Ontario. It's the rule book. So let's call it a rule book. Instead of calling it an act, let's call it a rule book. This is the rule book. For the court to have any authority to act, they have to follow the rule book. What is missing from Rule 136? Oh, that's right. What's missing from Rule 136 is that you have to ask permission of the court. So in absence of you being required to ask permission of the court, to ask for the court's authority to record your own hearing, the court doesn't have the authority to grant you that permission. And if the court doesn't have the authority to grant you the permission to record your own hearing, well, guess what? They don't have any authority to deny it either. Law is positive. And if it doesn't say they can do it, guess what? They can't do it.